Okay, so I'd like to welcome you to the third session for today. My name's Imogen Gould. I'm a fellow here at St Anne's and I work in the law faculty. This session is about genetic databases and clinical trial data. And our first speaker, Hastings McMahon, is from Newcastle Law School, where she's a lecturer in law. And she is principally interested in medical law and IP law, with a particular interest in patents and biotechnology. And today she's going to talk to us about publicly funded biobanking and intellectual property rights. Thank you, Aislinn.
Great. Well, thank you very much, and thanks again for inviting me here. I should say at the start that where this project arose from really was my interest in the medical law domain and IP, and sort of seeing that perhaps some of the issues around the recruitment of participants to publicly funded biobanks, which, as I'll suggest, focus on solidarity and communal benefits. There's a tension, arguably, between the way in which that's discussed in the medical context and the way in which some of the issues around intellectual property rights are discussed within the broader biobanking context, or at least a potential for a tension that could arise in that context. So in terms of this particular paper, it's really an exploratory paper, so I'd very much welcome any comments that anyone has in terms of how I'm framing this issue. It's a caveat, a usual lawyer's disclaimer, which is to say that I'm focusing specifically on intellectual property rights and in particular on downstream patenting, and how downstream patents which may arise as a result of individuals using samples from a biobank, how the downstream patents that might arise fits within the broader biobanking framework, and in particular how that fits within this discussion of and focus on, I would say, the need for having individuals donating to biobanks in order to increase public health, increase knowledge and awareness of disease, and this spirit of solidarity which has come to underpin many of the discussions around donation to publicly funded, in particular, biobanks. I should also say that I'm focusing, and what I say is in specific reference to publicly funded biobanks and large-scale biobanks at that. It perhaps has implications in terms of other biobanks, but the reasons that I'm focusing on publicly funded biobanks is I think there is an extra added impetus or perhaps need for us to consider public benefits and how those are translated downstream, and how to ensure public receive adequate and necessary and reasonable access to those benefits downstream, primarily because you have both individuals donating to these banks on an altruistic basis generally, but also you have public money involved in the funding of these banks, and that also I think adds this impetus to consider at least how benefits are translated. I'm also focusing on the European context and the European legal framework, and in terms of the central argument, as I've suggested, there's a potential for tensions in this context because patents, and we've talked about this and many others have mentioned patent as an incentive for encouraging innovation and downstream development of research. The question of whether the most or the only incentive for that type of endeavour is not one which this paper focuses on, except that patents can be an incentive for this type of downstream research, a very important one at that in the biotech and health fields given the costs of drug development. However, patents can, if used in an overly restrictive manner, they have the potential at least to act in a way which could impede downstream access. And if that is overly restrictive, individuals who are donating to the biobank could perhaps feel as if their contribution isn't generating the public benefits that they perhaps envisaged, or could perhaps become disillusioned by biobanking potentially. So there is a potential issue there in terms of trust, depending on how transparent the bank is and depending on how intellectual property rights downstream are potentially dealt with, I think at least. In terms of publicly funded biobanks, I'll suggest and show how donation has come to be portrayed in this collective spirit, which I think is a right and appropriate, and the need to deliver public benefits and access as a result of that. And intellectual property rights clearly are not incompatible with that. Indeed, they are needed if we accept the idea that patents act as an incentive. However, arguably we need to have mechanisms which ensure reasonable access for individuals, and also mechanisms which can ensure that individuals have access on, for instance, a basis that they can afford, and other facilities as well to ensure that. In terms of an outline of the presentation today, first of all, to set it in context, and given the audience, I won't spend long on this, but I'll very briefly give an overview of biobanks and the types of intellectual property rights that could arise, but we'll focus in particular on patenting. And then I'll focus briefly again on highlighting where solidarity comes into the discourse in terms of recruitment of individuals to donate to biobanks in the medical context. That then leads to this question of, well, who are the appropriate patent holders? And I'll suggest that and accept that the inventors or employers, or perhaps also a question of whether the biobanks themselves should have a share in this. That question will be considered. And then following, looking at that, I'll suggest that in terms of delivering on public benefits, and by that I mean also access to and reasonable access to knowledge around the disease or reporting back of findings to the bank, that we should have focusing on transparency, on ensuring appropriate preemptive actions of biobanks, using the UK Biobank as a case study for some of the types of mechanisms that could be used in this context, and also that there are mechanisms arguably within patent law, mechanisms to ensure public interest, such as the research exemption, which arguably could be considered and questioned whether those are most appropriately being used at the moment in order to ensure individual and public benefit is seen to the extent that is reasonable. So in terms of biobanking, biobanks, as many of you will know, are organised collections of biological materials stored alongside generally health data, and that generally is used by a community of researchers who can get access to this resource. They occur in a diversity of forms, from very small-scale biobanks to larger scales. There's also disease-specific biobanks, for instance, Parkinson's or dementia biobanks, and then also these broader biobanks like the UK Biobank, which is a large-scale, publicly funded biobank. They have significance for public health, and many would argue that if individuals contribute to these banks, that then leads to having a good and valuable resource which can then be used to make contributions in terms of investigating disease, investigating treatments, etc. In terms of the legal framework then for biobanking, broadly speaking, there's no one specific binding supranational instrument which covers all facets of this. Instead, as a recent report, 2012 report on biobanks for Europe suggested, that the legal instruments are in a mosaic-like form. They occur across different fields, different regulatory bodies, taking charge of various different aspects of this. And that can be complex in terms of biobank holders and stakeholders and individuals getting access to that information. Similarly, national frameworks is a variance of approaches taken in terms of this at the national level. There is some guidance, albeit not binding, but there is some guidance in terms of the OECD guidelines for human biobanks and research databases, which touch a little in terms of transparency and data and intellectual property rights, but not that much. There is also, of course, general provisions on patentability, which would apply here, including the Biotech Directive, which we've spoken about, and also the European Patent Convention. In terms of biobanks and the types of intellectual property rights which could occur, Pashmari and others have a paper from 2011 which highlights the different phases of the bank. For instance, you could have copyright in the health questionnaires at the collection phase when one is collecting the data. Similarly, patents in equipment, trademarks in the logos. At the creation phase, samples themselves generally do not get any benefit in terms of intellectual property rights, a point which I'll come back to, but there could be intellectual property in the data itself, so the database rights, etc. And finally, the area which I'll focus on, the access phase, where researchers are getting access to that material and then conducting research downstream. There could be potentially patents arising from that research further along in terms of technical applications or inventions that might arise. So, for instance, new medical applications, new uses of existing medicines, diagnostic methods, potentially. So a range of types of inventions that could arise, but of course that's research much further downstream from the biobank itself. In terms of then the first point, so if I'm suggesting biobanks as solidarity, where does that come from? Well, you can see this idea of individuals donating to biobanks or should consider donating to biobanks as a means of achieving solidarity, indeed in the Council of Europe recommendations. So this recommendation in 2006 on biological materials of human origin talks about using biological materials donated in the spirit of solidarity, and that contributes to saving lives and improving their quality. in terms of the most recent recommendation, which is the 2016 one, again, it talks about recalling that researchers should be allowed fair access to collections developed on the basis of donations of biological materials made in the spirit of solidarity. So we see explicit reference to this idea of solidarity, which in turn arguably implies this idea of reciprocity, or the idea that you're donating in the spirit of benefiting others. And then, of course, the question is, are those benefits, and to what extent are those benefits downstream made available, and is it sufficiently fair in the access, one might question. In terms of biobanks themselves, I've just have one example here is the UK Biobank. And of course, a large-scale publicly funded biobank talks about on its website the UK Biobank being a major national health resource, and then goes on to say over many years this resource will help build into a powerful resource to help scientists discover why some people develop particular diseases and others do not. But implicit in all of this, or explicit rather, in all of this is the idea that individuals, public members, are donating to biobanks in order to actively participate and generate this health resource, which in turn will be a benefit to society. So participation is in the public interest, and arguably in some cases is necessary almost for public health and generating those downstream benefits. And that's not to say that patents are incompatible with this, but I think there has to be greater discussion at least around how we're dealing with patenting and ensuring fair and reasonable access downstream as a result. In terms of this, then often people will question, well, so who should get access to downstream patents? And the first question, and I'm not going to argue that donors will get access to downstream patents, but some suggest or at least look at whether or not individual donors should have any share or any control or any ability to benefit if there are profits from this, these types of, or donating their samples rather. As others have said yesterday, there's no intellectual property in the body as such. Article 5 of the Biobank Directive makes that very clear. Instead, patents are available only for inventions. They are available, however, for isolated elements of the human body, which again is evident in Article 5.2. But if patents are successful on that basis, they would go to the patent holders, not to individual donors, because the individual donors would not be involved in the invention or the creation of that process. So donors' biological sample, that contribution is irrelevant to the intellectual property. There's no application of skill by the individual donor themselves. Nonetheless, this has caused controversy. So, for instance, the HeLa cell, which I think others had this in their presentations yesterday as well. So Henrietta Lacks, which I'm sure many of you are familiar with, whose biological specimens were used to create, without her consent or knowledge, a HeLa cell, which was then used to around the world and arguably generated a lot of profits for those involved with that, but not to the family itself. So, and this again, I think, is subject to a recent HBO documentary. So it's in the media again in terms of individual donors and the extent to which they should benefit, if at all, from research of this kind. However, the most, I suppose, high-profile case is Moore versus Regents, University of California, where, again, an individual's biological sample, again without his consent or knowledge, was taken from his spleen and used then to create a cell line, which was very profitable for the university itself. However, Moore was held not to have a share, or not to have the ability to have a share in that patent. So some argue that there's a double standard there, that if individual companies can benefit from this, then why shouldn't the donors themselves benefit? And I think that's a question which is in a different context. If we look at HeLa or if we look at Moore's, in the biobanking context, I think it wouldn't be advisable or desirable indeed for donors to have any control or share in profits, primarily because, first of all, at a principle level, attributing intellectual property rights or a share in the profit to donors, that's not necessarily what they wanted when they donated in the spirit of solidarity. But more practically, how would you ascertain who would benefit from these? Because HeLa and Moore's case, I would say, are very exceptional examples. So most likely you're going to have numerous samples used with numerous other data. So the extent to which you can derive an individual who contributed to that would be difficult to ascertain. Furthermore, even if you could ascertain who should benefit, the question would also be it would complicate the intellectual property regime because it would be multiple individuals, and that in turn could hinder downstream research. So I don't think there's any basis in that argument. Then instead, you could look at, should patents go to the inventor or the employer, which generally is the case, as we know. Unless it's stated otherwise in the material transfer agreement, patents would arise to the individual inventor or employer, depending on their contracts of employment. Patents share for the biobank, sometimes this is also debated, and this tends to be discussed in terms of the contribution of the biobank. Did they actually contribute to the knowledge that arose? And that again would be dependent on their role in terms of downstream research. However, some argue that the biobank should retain some sort of a share or control in terms of intellectual property downstream in order to have a say in what would happen to the invention. Now, that could very well work depending on the context, I think, of the biobank and their relationship with individuals that are using the bank. However, it could also have the potential to complicate intellectual property arrangements, to complicate access arrangements, and also potentially to act as a disincentive for researchers. Nonetheless, solidarity, if the focus is on public and not individual benefits, as I've suggested, patents are not incompatible with that. Indeed, they are limited in duration. They're also useful mechanisms to incentivise research, but then we need to think about the types of benefits and the types of mechanisms that are used in order to translate these public benefits. And I will say in this respect, there's three main avenues that I think should be considered. First of all, transparency in terms of informed consent. So arguably the Gila case and also John Moore's case, there was no discussion with the patients in those cases. Informed consent, highly questionable, and indeed in Moore's case, that indeed was subsequently the subject of a successful action, highlighting that there was no informed consent there. In order to ensure individuals are donating to the bank, whilst it's important to have informed consent, it's also important within those discussions, I think, to have a discussion of downstream commercialisation in order to ensure that individuals are aware of the potential for patenting and commercialisation, and that in turn could support this relationship of public trust if individuals are aware of this. And indeed, this is recommended in the guidelines, in the 2009 OECD guidelines. You can see there they highlight the need to have a clearly articulated policy, which most biobanks would have, and also to have that policy would reference intellectual property rights. And similarly, the recent 2016 recommendation talks about the role of good and transparent governance. So, and again, it also has a specific article on access, Article 18, which talks about ensuring measures to facilitate appropriate access by researchers to these collections of biological materials. So transparency, I think, is key in these types of discussions, but it can't just be transparency, because if individuals donate, they will expect a reasonable return for research, and how then to balance that with the need to have intellectual property rights. So an example of this, and it's not the only example, but I think it's useful to consider how the UK Biobank have developed their intellectual property. So in terms of the mechanisms for ensuring access and delivering on benefits, they have, I think, main areas here which are of interest: the publication and reporting policy, the licensing policy, and the restrictions that could potentially apply if patents are used in an overly restrictive manner. So in their access materials and intellectual property policy, the UK Biobanks highlights, first of all, that there's no preferential access. Access is available to all bona fide researchers. And they also talk about intellectual property rights. It's an approach to encourage researchers. And whilst they have ownership of the samples and the data, the UK Biobank does not have any claim in terms of downstream intellectual property rights. The only circumstance where it would have is if intellectual property rights are used in such a way as to restrict health-related research and or access to healthcare unreasonably. And you can see there the specific text of that provision in terms of why they're using that. And in discussing that, they also interestingly say they would not expect naturally occurring genetic sequences, biomarkers, proteins, or biochemical processes to be made the exclusive preserve of one party. So obviously a policy decision taken within that context. And they also talk about not using intellectual property rights in an unreasonably restrictive manner. If one does so, the consequence of that is that it can require that a license of such right is granted back to the biobank on an irrevocable, perpetual, global, royalty-free, fully sublicensable basis. There is a consequence of that, But in terms of proving that it was unreasonable access, there's limited amount of information within the policy itself and no definition indeed in the policy which defines that. So that's potentially problematic. But nonetheless, this is one of the mechanisms they are using. Similarly, they also have reporting mechanisms. So thinking about benefits in the broader sense in terms of ensuring that other researchers have access to knowledge or information generated. So PIs are required to use best endeavours to publish their research deriving from the resource. Summaries of the research findings are put on the website along with links to relevant publications. And then in the material transfer agreements, you have discussions of the need to have periodic updates to the bank of progress on the research and a copy of any patents whose claims cover or are intended to cover an application-generated invention within 2 months of their publication. So those are some mechanisms that could be used and need to be thought about before the biobank comes into effect in order to generate these types of facilities for generating public benefits. However, I also think there are provisions within patent law that could be used to generate broader public interest benefits. So for instance, there is a research use exemption, which many of you will be very aware of within patent law. However, it's quite narrowly interpreted. And the other difficulty with this provision is that the scope of the provision differs in European countries. So that could be an issue in terms of collaboration for individuals. And also because the narrowness at which it's interpreted, again, generally it would only apply to research done for experimental purposes relating to the subject matter of the invention itself. And that has been interpreted very narrowly. You can see here under the UK Patent Acts and under other national provisions. Also, if there's a commercial motive behind the experimental use, it's very unlikely that that would come within that exemption itself, at least within the UK. So perhaps there could be consideration of this type of provisions or licensing provisions or other provisions after patent grant in order to consider how that could be used for individuals wanting to generate better or more research and feel they are perhaps hindered in that in terms of patenting. And the other thing that I'll suggest, quietly suggest, that arguably there are other provisions in patent law that could be used, for instance, at the patentability stage. So one provision arguably is the morality provision, Article 6 of the Biotech Directive, which talks about commercial exploitation of which is against order public or morality. Now that provision has been extremely narrowly interpreted within patent law, with the exception of a more recent case in Bruce Lee and Greenpeace. Now, that case itself focused on an interpretation of one of the specific provisions of Article 6 of the directive, so arguably it's different from if you were to look at this in the general context. But nonetheless, there is at least an argument that one could see order public as connecting to human rights. Yeah, I'm going to finish up on this. And arguably, I can say more on this if you wish, whether or not upstream inventions, if they hinder health, could we consider these under the morality provisions? However, I do acknowledge that would be a delicate balance and it's questionable whether it would be appropriate to consider those at the patentability stage. And just to finish on this point, in terms of bridging health and public and intellectual property discussions, I think there are different discussions going on in the health versus IP context. And some, such as Jolie and Dove, talk about this and arguably the contested futures for these, given the focus on solidarity on the one hand versus the focus on individual or intellectual property rights. And I think arguably there's a need for greater discussion or dialogue on the delivery of benefits in this context. I'll finish there. Sorry for going over.